Good morning, everybody. Thanks for having me today. Just a quick housekeeping rule: if you have any phones, if you can put them on off, I'd greatly appreciate that, so that if your phone does ring while we're talking, that we don't it's not disrupting anyone else. Okay, so just a little bit of information. How many people are new to business? How many have set up their own business and are running and operating it? So the rest of you are just here for information? Is that it? Okay, perfect. So, essentially before we go through the presentation, I'd like to give a few housekeeping rules on running and starting a business. So I've been practicing law for about 12 years. And I mainly represent small to mid-sized closely held businesses. So one of the things I like to do when I lead a workshop like this is to give you guys really practical tips about thinking about running and operating your business before we get to the subject matter content, because I'm a big believer in the fact that business is built on foundations. And as an entrepreneur, you need to know the 2 or 3 critical practical points before you build your foundation, okay? And before you're out in social media promoting your business, and before you get employees involved in helping you grow your business. So the number one thing that you have to think about before you start your social media campaign or you do anything in business is to become a subject matter expert. Okay, so no matter what type of business you are going to run, you need to know everything about that business. So start by becoming that subject matter expert. So there are several ways you can do that, right? There's the World Wide Web. There are books written practically about every single business known to mankind. Find a book. And then 2 is just navigate any sort of blogs that are relevant to the type of business that you're doing. The reason you want that is because then you have access to information. You know what the industry trends are. You know what you're looking for. You know the information that it takes to run your business. So once you have that information, the second thing you should do is seek out a mentor or someone who you think is a subject matter expert in the type of business that you want to run, and invite them to coffee or lunch. Okay, and why you want to do that is you want to be able to talk to them about what you read about, right? Ask them advice. And that conversation is so beneficial to you as a new entrepreneur, because what it does is it puts you on the learning curve of someone who's been really good at doing what you want to do, okay? So subject matter experts, seek out a mentor, like we said, because you want access to information. The second thing is, you want to think about building an advisory team, right? People who are going to help you navigate the business landscape. And the reason you want to do that is they're qualified or curated people by you that are really good at the type of business that you want to run, or who have been entrepreneurs, or who have strategic relationships that they want to give you, because then it makes an idea that you have so much more powerful, because you're getting access to their information, their knowledge base, their expertise, their wisdom, right? And that is, kind of the fundamental first steps, right? You want to exchange information with other people, but you want to also gather information, and you want to curate your team, okay? So think about entrepreneurship as not only, you have the idea, but it's like playing sports. You got to build a great team, and you got to build a great knowledge base, okay? And so there's your internal team, kind of your advisory board, and then your external team. Okay, those people might be your lawyer, your accountant, your insurance agent, your banker. Curate those people as well, okay? Meaning go out into the marketplace, find the people that are really versed in the type of business that you want to do, and then, obviously enlist their services. So why that's critical to you is because once you have a great team, and once you're operating from the standpoint of knowing what you need to know about your business, you make better decisions as an entrepreneur. And so no matter what type of, issues we're talking about today, whether it's, social media, or whether it's, corporate governance, or whether it's, best legal practices for entrepreneurship, it starts with you, the entrepreneur, having had that solid foundation. And if you don't have the solid foundation, you don't have a good team, you haven't done your homework, you don't have a mentor, you just have a really great idea, don't start a business, okay? Because it is a very, very difficult endeavor, and you want to be prepared, okay? So along those same lines, I'm a big fan of business plans, okay? So if you don't have a business plan, write one. There is no right answer, right? It's just essentially a plan that you come up with, right, that's going to give you some sort of roadmap or framework on running your business, right? It should fundamentally answer one question: how do I make money, right? And if your business plan doesn't address that question and give you some sort of roadmap, then that's the error in the business plan, okay? There are so many resources available to you through the city of Chicago to help you write that business plan. Take advantage of them, just like you're taking advantage of this workshop. And the only reason I'm telling you about these practical tips is because everything in business builds on something else. So it's like baking a cake, right? If the first layer is shaky, the whole cake's gonna fall, right? So my point to you is, think about these things as practical first tips before you even think about marketing or promoting your business on social media, okay? Do you have any questions about anything we just talked about right now? Okay, so, today we're gonna talk about 4 topics: social media's prevalence in business, 10 common legal issues with social media, best practices for employers, if you were to have any employees, and then marketing and social media. I'm not going to read off the slides, but because you have a copy right here, but what I'm going to do is extract the information from the slides that I think is relevant to you as a business owner, and then you guys can read the slides afterwards. Okay, so we know the statistics, right? 1 billion Facebook users, 300 million Twitter users, 300 million Instagram users, and 70 million bloggers. So meaning this social media is rampant with the exchange of information and commentary, right? So how do you, protect yourself as an entrepreneur/employer? So the first thing is, before we go to the 10 common legal issues, is your name, the name of your business, and essentially your trademark, right? So this is further down the line. But, just like we began the class about the foundational elements to running a great business, you have to think about your intellectual property on social media. So your trademarks, right? Has anyone ever, come across the word trademarks in the past? Okay, what do you know about them? They're expensive. Whoa. Besides they're expensive, what's the use of a trademark? If you got a trademark, it protects you. But what's the use? What is it?
Branding.
Yeah, it's a branding element. So what it essentially is a mental shortcut. Okay, it's a mental shortcut for a consumer to essentially discern where the source of the goods and services are. Okay. So where are the products or services coming from? So McDonald's is a trademark, right? If you go to McDonald's in France, if you go to McDonald's in London, if you go to McDonald's in the United States, as soon as you see the golden arches or the name McDonald's, you know what the source of the, goods is. You know how McDonald's will look and feel. You know what type of food you're getting. So trademarks are essential to branding a business, but essentially why you care is once you're on social media, right, your name is out there, your brand is out there, okay? And regardless of what you think, once you're on the internet, you're doing business globally, right? It's the World Wide Web, right? So from your standpoint as an entrepreneur, one of the things that you have to be careful with on social media is, do you have a protectable mark, or are you infringing on someone else's mark, right? The unauthorized use of someone else's trademark. So how you protect yourself from the standpoint of the entrepreneur to begin with is register your mark, okay? But before you register it, you want to make sure that it's available, right? No matter if you think that you can get I have a ton of clients who will see a name of a business that they like for the type of business that they're doing, and they love the name, so they're like, oh, that person's in New York. I'm going to be doing business in Illinois. Once you've done your search and you've found that someone else on the web has that same name doing business in the same industry you are, reaching out to the same distribution channels, do not use that name, right? Because if they were using it before you, that's intentional infringement, right? You knew about it and then you used it, right? But more importantly is if you're going to spend all the time and the resources to really grow and develop a business, the last thing you want to do is be at this for 2 or 3 years and then get a cease and desist letter from someone else, meaning stop using my mark.
What if you notice that somebody internationally is using that same name?
Yeah, so internationally they might have U.S. subsidiaries, or if they've applied for registration in the United States, you cannot use it. So if they've been registered with the United States Patent and Trademark Office and you continue to use their mark, there is a statute called the Lanham Act that essentially protects a trademark holder by saying if someone were to prevail against you in a likelihood of consumer confusion action, meaning you and that person are using the same mark in the same way to the same distribution channels, then you owe them 3 times their damages plus their attorney's fees, right? So from your standpoint as in business, you can make more money, but you can't get back more time, right? No matter how rich or powerful you are, you have 24 hours in a day. And once that day goes, you can't get it back. Why I say that is, having to change your name, rebrand, getting into litigation against someone for a name is a waste of money and time, right? And the point is like, here you are, you've branded your business so well, and all of a sudden, guess what's happening? You got to change your name, right? You got to rethink about, that means your business cards, your website, the way your consumers know you, right? So all of a sudden, you've just lost out on a lot of time and money. So think really carefully before you use a name, but more importantly, make sure you're doing a search and you're not using someone else's name, right? The other thing that people do on social media is they might like pictures or photographs or web streams or things of that nature that don't belong to them. And then they suddenly are building their website and they take those things, right? Once you take something of protectable nature, like for example, someone else's copyright, right? Their original expression fixed in a tangible medium, their picture, right? The way that if they wrote a story, the way that they describe their business, and you adapt it as yours, you're unauthorized to do that, right? If it's theirs. So when you're copying, right? When you take a picture, so the best way to go about doing anything like that is to ask for permission, right? And that's up to the copyright holder, right? The person who created the work to give that permission to you. But you do yourself a disservice, again, by building your website or some of the things that you're doing by the unauthorized copying of someone else's work. Go ahead.
So can you make a best effort to contact that person?
Yeah, and if you can't contact them and you haven't gotten their permission, you still can't use it, right? If it belongs to someone else, you can't use it unless they say you can use it, right? So, think about it from that standpoint of like, go ahead. Sure.
Suppose there's a picture you've taken of some people and you've asked maybe some people or a particular person can use their image verbally, or do you have to have it in writing?
Well, I mean, it depends on what you're using it for, right? If it's for commercial purposes, if they're in public and you take the picture, then you can use it. If you take their picture and you're trying to sell something, right, then you can't use it, right? So it's the reason that people hire models and then they pay them to promote their goods and services. I'm just giving you like an example. But if it's in the public and you're taking a picture while you're walking out on the street, you know, and then you put it on your website, you know, it depends on the nature and the facts, but more likely than not, you know, that would be an allowable use. You know, one of the things is the other thing that you have to think about as your organization grows, or you think about the intellectual property in your organization, like your trade secrets or information that you tell your employees. You know, people are on social media talking about everything all the time. So from a standpoint of being an employer entrepreneur, one of the things you guys really need to think about is how do you protect yourself internally as an organization from disclosure of confidential information, right? So best practices for any of you guys should be non-disclosure confidentiality agreements with your employees. And enforce those, right? If there is something that's really unique to your business and it's a trade secret, make sure it's kept secret. You know, make sure there's a protocol in place, but more importantly, make sure that your employees are signing off on those non-disclosure agreements and those confidentiality agreements that prohibit them from discussing that sort of information outside the walls of the workplace. So that if your employee does disclose any sort of confidential information on social media, then you have a right to terminate them. But one of the things I'm going to say, and with a caveat, is, you need to be clear about your social media policies, but you have to enforce those policies across the board, right? You can't play favorites. So everyone has to sign the confidentiality non-disclosure. Everyone has to get that sort of training about the social media policy as it relates to trade secrets and confidentiality, right? Because if you do not, if you enforce it on, you know, one person and not another, you might be looking at a discrimination lawsuit, okay, depending on the nature of the facts. So make sure that that sort of information, that disclosure of information, there's some sort of protocol. You know, we talked about the unauthorized use of trademarks. I told you how, you know, you should definitely do a name search. But more importantly is if you can register a mark, you need to register it, right? And what I mean by registering it is registering it with the United States Patent and Trademark Office. So the filing fee is anywhere between $275 and $325 per class. So, you know, depending on what type of business you're doing and how many classes / categories that falls into, the filing fees might be higher for you, okay, if you need to get a mark in more than one class. But, you know, what I would recommend doing as, again, general practice for you guys is start by doing a Google search, right? See if that name is taken. Go on the Illinois Secretary of State's website, see if that name is taken. And then you can go on www.uspto.gov and do a trademark search, right? It's on, you know, you'll see it. The website's actually very easy to navigate. And you could see if any of the, you know, the mark that you want has been registered or is pending registration. So I definitely, you know, recommend that before, you know, you get on the web, again, because you're doing business internationally and starting to use the mark. We talked about the unauthorized use of copyright protected works. So the need to seek permission, right? If it's not yours, you got to get the copyright holder's permission to use it, okay? And that's, you know, that's the number one way. You know, people see pictures they love or videos that they want, and they automatically, you know, take those videos and they adapt them as their own. Again, that's the unauthorized infringement of the, you know, the original author's work. And then you got to think about, you know, what your employees say on social media or what you say on social media and whether or not it's defamatory, right? You know, just because, so here's how defamation works. Obviously, there's constitutional rights of free speech, but just because you know, one of the things I say is anyone could sue you for anything, right? Whether or not they prevail is a different story. But our point is we want to adopt best practices so we're not trying to see who's right? Because when we try to see who's right, whether your statement is defamatory, then what's going to happen is you're going to spend a lot of time and money. So you're never going to get back any time, and you're going to lose out on a lot of money. And my general benchmark practice to every entrepreneur is don't call your lawyer. If you think it's defamatory, don't do it. Okay, so if you're about to write a statement on social media and you're like, will this person come after me? That means don't do it. Okay, because regardless of whether or not the legal nuances are that you would prevail and it's not defamatory and it's free speech, do you want to risk the time and the money to be caught up in a lawsuit to prove who's right? Right? So my point is, from that sort of standpoint, be careful, right? You know, the other thing is, electronic document retention. If you were to get sued, social media is discoverable information. You know, you can't wipe out anything. You know it's still there in the web somewhere. But if you get sued, you know, some of the things that might be called to action, or if you're trying to enforce your, you know, for example, your trademark rights or things of that nature, your tweets are going to matter, right? Your social media history is going to matter. All of those things that you posted on social media are going to matter, okay? You know, think of social media from the standpoint of, you know, the dynamic information, right? The exchange of information between one party to the other, the exchange of information of everybody, right? So, you know, one of the things is some social media, like Wikipedia, can be edited by almost anyone. So company employees might edit Wikipedia entries. Be careful when your employees start editing social media content, because more likely than not, sometimes it's more harmful to you than it is beneficial, right? Because then your consumers are like, well, why is this person erasing or editing things, okay? So just be careful from that standpoint. And then, you know, human resource issues, right? You know, from your standpoint is be very cautious about using social media from someone's Facebook, for example, and deciding whether or not to hire them, like, for example, their religion, their race, their gender, because if it can be proved that you are on their, you know, if you were checking their, you know, Facebook or Twitter to recognize those things in order to make a hiring decision, then you're looking at discrimination actions. And then, you know, from your standpoint is what your employees post on social media, right, could be a source of terminating them, right? If they are going to release any sort of confidential information, okay? Or they violated your employment policies and procedures, if they're harassing another employee, right? So just think of social media as this open forum that everyone starts talking on. But from your standpoint as an employer, knowing all of these things, it goes back to the preventative things that you can do in your business. You know, your employee handbooks need to have a good social media policy. You have to have non-disclosure confidentiality agreements. You have to have anti-harassment policies, you know, with respect to how your employees communicate with one another. You had a question?
I do. I'm understanding what you're saying. The potential for lawsuit if they can prove that you've been discriminating based on their social media activity. Would that still have to fall under one of the 17 protected classes? Or, for example, if I looked and people who were always in bars, I didn't want to hire them, you know, that they're always posting what a good party time they have.
Yeah.
So would the discrimination have to meet those protected classes discrimination?
Yeah, like in terms of discriminatory, yes. The cause for termination, what I'm more concerned about is if someone harasses another employee at work, you know, via social media, and you have an anti-harassment policy in place, and that person is not, you know, respecting that policy, and that the employee that's being harassed comes to you and says, look at all of these posts. I mean, I've had that happen before, you know, and it's creating a really hostile work environment for someone, and especially if they fall in a protected class, right, or a certain, you know, religious denomination. Or, you know, you have these sort of, you know, confidential information or product launches that you're doing, and all of a sudden this person starts talking about it on social media. Well, what that does is it opens it up for your competitors to know about it. So from your standpoint, that's terminable, right? Because they have signed a non-disclosure confidentiality agreement, and they've essentially told the world, right? They told the world. So the reason I say all of these things and thinking about it from a preventative nature is once you have the protocols in place, once you're communicating with people what your policy is, not so much of telling them what they can and cannot post on social media, but as it relates to your company, right? The confidentiality, trade secret, non-disclosure of what is company business and what is personal business, right? Then people are on the same page, right? And the reason you care about this is how does everybody now communicate if they're having a bad day? Their friends know about it, right? The whole world knows that they're having a bad day. If they're eating pizza for lunch, who knows about it? Everybody does. So my point is, you know, people have looked at social media as a forum of communication, and it's really open communication. As an employer that's trying to build your business, what you really care about is, are there protocols in place in my organization to protect me from this kind of, you know, unfettered disclosure that happens on an everyday basis, right? So that's what I want you guys to think about. So an employer can't terminate an employee because of their social media activity if they did it on work hours and it is in violation of, for example, their non-disclosure confidentiality. You know, but again, be consistent in the punishments in order to be fair, right? You can't, like I said, you know, before, is you have to apply the rules across the board equally, right? And if you have a situation that does occur, from that standpoint, my number one thing that all employers fail to do is write-ups, right? A lot of, you know, it's not social media related, but a lot of like employment issues are about lack of communication, right? Someone doesn't know that they did something wrong, or someone doesn't know how to fix it. So general practice is your write-up should always address what I call the offending behavior. What is it? What's the rule? Let me, you know, backtrack and say, start off by saying, what's the rule, right? What's the policy in place in the company? How did that person violate the rule? What did they do that's wrong? Because as soon as you write someone up, what happens? They become defensive, right? They didn't do anything wrong. So what you want to do is start with a policy, tell the employee how they violated that social media policy, you know, and what they need to do in the future to fix the behavior, right? You know, so again, what's the rule or the policy? What did the employee do that was wrong, and what do they need in the future to fix it? And you got to be able to communicate those things, okay? Because, and again, apply the rules fairly across the board, you know? That's when you have problems. So we talked about confidentiality agreements. You know, if employees violate FTC endorsement rules, or if you're marketing a product and an employee, one second, if you're marketing a product and an employee all of a sudden, you know, starts to say things about the product that are true and not true and inaccurate, right? And so remember that if someone works for you, you're the principal and they're your agent. So, right, if they're on your website, you know, lying about the attributes of a product, or, you know, making things up, then it's attributed to you as the employer, right? So make sure that, you know, they're not violating any sort of, you know, marketing claims or anything like that, or they're not threatening another employee, right? And like I said to you, I did have a situation actually this year where it was a threat over social media, right? Depending on the nature of the threat and how imminent it is and how you have to provide a safe workplace, you might want to terminate that person immediately for something like that.
This has to do with non-disclosure. If you have a product and you want to go to a company and present your product, they refuse to sign the non-disclosure, saying, oh, we have this in our pipeline, so we're not going to sign it because we're already thinking about it 10 years ago. So what do? Do you just say, get it to the company?
Well, it depends, right? If they made a hard stance to you that we don't want to talk to you and we won't sign your, confidentiality agreement, then you as an entrepreneur have to do a cost-benefit analysis in your head, right? Is it worth it to you to proceed under the terms that, they won't sign your non-disclosure? It's risky, but then you're like, well, maybe if they see what I have to present, that might steer them to do business with me. But, you can't short of going to someone's house and, shooting them, you can't force them to do anything in this world, right? So that's a joke, but, and probably an inappropriate one. But, so think about it as you can't force anyone to do anything. Whenever you're at an impasse in business, you have to do a cost-benefit analysis for yourself to say, do I want to proceed under those terms?
What if you present it and you say, okay, I'll present my product, and as soon as they see it, they say, oh, we've had this in our pipeline 10 years ago, and they really haven't, but they're going to make it into their.
Well, that's a risk you took, right? And in business, there's always risks, right? You can be, even if you have a non-disclosure agreement sometimes and someone signs it, they'll still turn around and copy you. And so from that situation, then you have to ask yourself then you have to litigate, right? You have to sue them to say they were in violation of your non-disclosure, non-compete. Now, I want to tell everyone in the room this, ideas in and of themselves are not protectable, right? So I could, because what you have to think about ideas is I could sit in the room and come up with 1 million ideas, and I could call them all my own, right? The law doesn't protect ideas. So it protects original expressions of ideas, right? So you can get, if I take a photograph, that's an original expression fixed in a tangible medium. But if I say I have this idea to do this, this, and this, someone could have the same idea, but they can express it in a different fashion. Or, they could have components that are, not like mine. So, when you come to the situation where you're really trying to protect an idea or a concept, what you're more apt to look at is, do I want to disclose it, right? Because again, if you have a non-disclosure confidentiality agreement, just because I sign it doesn't mean I'm gonna, I might think of a different way of approaching your idea, and then if you sue me, what are your damages, right? What did you really lose out on? Because the idea is not protectable. So you got to think about it. Always do a cost-benefit analysis in your head. And then when you're talking to someone about something, is you want to give them just enough information to get them to talk about a deal with you, but you don't want to give them the kitchen sink. So if you've done a lot of research, if you've done a lot of development, those are probably things that you don't want to give away, right? But, laying the framework or the architecture for the idea that you're trying to do might be something that you want to give away just to get the conversation going. So just cost-benefit analysis. Does anyone have any questions about that? Okay, keep going. That's not really. Then there are privacy policies that you might have on your website, or end user agreements that people who are using your website, whether it be consumers or clients or, anyone that's looking at your products and or services and has to sign what's called an end user agreement, which lists kind of your policies, they're the long agreements that no one really reads and presses agree, right? So make sure that although people are pressing agree and you have some sort of privacy policy in place, that you're abiding by that privacy policy. So that means that was an agreement between you and the end user, right? Me, who gets on your site and starts to use your site and gives you all of this information to keep that information confidential. You want to abide by those privacy policies, right? So, I wouldn't take them as, it's just a formality. I need to put it on my website. Be sure you know how you're disclosing people's private information. The other thing is if you're collecting credit card information, data privacy or data security laws apply, and that's a whole different seminar. But, for the purpose of this kind of survey class, is you want to really look at those privacy policies and those end user agreements and make sure you're abiding by the agreement, right? You're keeping people's information, their private information, confidential. We talked about FTCs and regulations like Federal Trade Commission regulations where if you endorse a certain product on social media without disclosing that you're getting paid for it. So the example is fashion bloggers need to say if they're getting paid by, for example, Lord & Taylor or whatever for wearing a certain dress, right? Because they're promoting that and they have all of these followers. So if you're getting paid by someone, you need to disclose that. And then, if someone, so if you're an employee and you're endorsing your company's products or your employees are doing it, they have to disclose that they're working for you. Go ahead.
So let's say that your website has a place for your customers to comment, to rank your product or your service or whatever. And because it's on your website, obviously you have some control over that. Without modifying what the customer may have written, do you as the owner of that website have the right to choose which of those things you may or may not post?
So what do you mean? So
for example, I go on Amazon and I write about this product. Oh, it was an awful product, it was cheap, it didn't arrive on time, Amazon customer service stunk, I'm just totally unhappy with that. But I'm on Amazon's website and they allow me to make the comments. So do they get to decide which of those comments they post? Well,
on their website, they might have in their, user policy, they might have a clause in there that says, we retain the right to remove those posts. But then if you post on a third-party website that Amazon has no jurisdiction over, so to speak, then you're allowed to do that. It's free speech, right? You were dissatisfied with the services. There's a different, there was a case in real estate just recently, and I don't know how it's shaken out, but this woman was, basically saying this real estate management company, all of their homes have mold in them. So she got mad at one of the people at the management company and just went on a tirade all over social media. And they're suing her for the fact that, it's hurting their business. Whether or not, depending on what the facts of that case are, just in that, from that sense is like she has the right to say what she wants to say, but it has some consequences. Like we said, she's slapped with a lawsuit now that she has to defend. So just be, like in your situation, if, your product arrived late and you had a bad customer experience, you can do that. That's free speech, right? People do it every day. But then there's a difference between you going on a social media campaign and saying something that's false about someone else with the intention of, limiting the type of, limiting the amount of business that they would be able to call, So it just depends, fact intensive.
Example, you talking about the blog. Like when you post something, you
Yeah, these are our paid sponsors. So you would have to, if you're getting paid for something, you have to disclose that you're getting paid for
Every
it.
time.
Well, so usually it's, if it's a different, like let's say, Gap pays you one time and Lord & Taylor pays you another, and then you do this like paid advertisement, you have to disclose that you're being paid to say, okay, I'm endorsing a Gap turtleneck, because it's it's sort of a paid advertisement. So, but then, if you have an ongoing relationship with Gap, then you would just make that disclosure on your site so that if anyone were on it, they know that this is a relationship that you have with Gap, that you're getting paid by Gap. Okay, does that make sense?
Yeah, no, because my question is for Instagram, because people get your picture and then you put other brands, but I never seen something like that.
Well, they're probably not getting paid, right? It's only if they get paid.
Okay.
Yeah. So if I'm wearing my Gap turtleneck and I'm like, I love my Gap turtleneck, I can do that, right? Unless I keep posting on social media and I'm like, Gap's paying me to say I love my Gap turtleneck and I have 300,000 users. Do you know what I'm saying?
Yeah.
So if you're getting paid, that's the issue, being paid.
Really quickly, if you're doing a data capture on your website, have like an internet radio station, and so people can fill in and just fill in their names and emails for newsletters or info or new music being released or any of that. Should I post somewhere or have a small line, like when you go to Apple Agreements, for them to check off to read a full public, private policy, or should I just have like a little note or mention your name or your name's pretty given to a third party?
You should have a end user agreement / privacy policy agreement in place.
I have a small one, but it's not like when you go to Apple and it's like full.
Well, it's
like
not.
14 contracts.
It's usually not the size of the user agreement that dictates whether or not it's effective. It's the content. So, just
I'm
because.
hitting all my points in like a paragraph.
Yeah, I would definitely recommend speaking to an attorney about that.
Yeah, I was gonna say.
Yeah. So
Okay,
for
so,
sure,
yeah,
for sure.
Thanks.
Okay. So, best practices, like we talked about, ensure your confidentiality and NDAs are in place, establish a clear social media policy. So one of the things we, said is, the number one way that there's a communication gap between you and your employees, for example, is when there is no communication, right? So make sure that everyone has and is communicated that social media policy. One of the things that you might consider is potentially putting it in an employee handbook, or before someone works for you, here are the rules, right? And then have them sign off on it. So anytime you give, any sort of direction to anyone, I would recommend them, signing off on it, because then it evidences that you and them, were on the same page, right? And then be aware of using social media to make hiring or firing decisions, like we said. So you want to just keep those. Sure.
I have a friend that was a district manager, or I went to school with a guy. He was a district manager for Enterprise, and I don't think they do drug testing, but he was fired because they saw that he was partying and smoking weed or something, or it appeared that he was smoking a cigar online or on his social media outlets, and he was fired. Is that legal?
Well, it depends on the nature of those facts. Like him partying and then making the decision to fire him between seeing that he was partying, because everyone does, right?
Everyone does.
So it just depends on the facts of that situation. Yeah, exactly. So, but don't, for example, make hiring decisions because you're on social media checking out the race or religion or yeah, exactly, and someone knows about that. So make a clear social media company policy, like we said. Define what your company's social media voice is and be consistent, whether it's on the level of your employees or whether internally, right? Your trademarks, the copyrighted works that you're going to use, make sure that you're not infringing on any of those copyrights that are not yours, and make sure that the name, the identifier of your goods and or services is essentially your voice, right? And then be responsive whenever you see a situation occur on social media for your company that violates the company's social policy rules, right? You don't want to let a long period of time elapse, because not only does that increase the gap for risk and liability, but if you were going to discipline an employee and you waited on that for a really long time, then then is it really a policy, right? So now I want to open the floor for some Q&A, thinking about some of the things that you guys might have from the standpoint of any questions that you have on starting a business or anything related to social media or disseminating information on social media. I'm happy to answer any of those questions. Go ahead.
What was the name of that website? USPTO?
No, USPTO, P as in Peter, T as in Tom,
What you say again? US?
PTO.gov. United States Patent and Trademark Office. Okay, so if you're searching for a name, I would recommend going on that site. I would recommend Google and then Illinois Secretary of State's website. So you're hitting some major databases.
Do nonprofits have any leniency or?
No. No. The rules are applied across the board. No.
Hi,
Hi.
I'm developing myself as a social media RN, and I was very excited at first to look into partnership. And partnership is very challenging, and also there's some do's and don'ts.
Yeah, so HIPAA, an RN being a registered nurse.
Yes.
Okay, so for you, you have to be really careful about what you're disclosing in terms of like clients or patients, because you're bound by HIPAA rules.
No,
right?
but my platform is well-being.
So you're just writing a general
Yeah.
well-being?
Inspiration, motivational.
Okay.
But what I'm saying is like, the vision is that well-being and healthcare information is more propagated through the media. So like, radio, television, social media. So I was always gravitated to partner with people who already have some media, and I'm finding that, the do's and don'ts of it.
Yeah.
And it's not that easy, because they already perhaps have established themselves, and then by the time you come in, it seems like it's very challenging.
In order to find a social media partner.
Well, more on the radio and television aspect, so which really keeps me more on the not-for-profit side.
That's not mostly a social media issue. That's more of a finding a right business partnership issue,
So it's possible.
Anything in business is possible. It's just how willing you are to put the work in. That's the one thing I would tell everyone in the room. Starting a business is really hard. Okay, so if it were easy, everyone would be doing it, and not everyone does it, or a lot of people do it, but they don't do it right. So, you're going to end up facing hurdles like that, where your partnerships don't work out, or you're trying to get a vendor or a client or a strategic alliances, and that doesn't work. It's just like, do you have thick skin? It's like sales. You got to go out there as an entrepreneur, and you're selling in some way, shape, or form every day. So, it's not going to be easy, right? But you got to be willing to stick with it if it's something that you think that's worth it, and you got to keep turning over the rocks. And so that's the point. Part of it is, whenever you're trying to negotiate something with anyone, is like, you have to ask yourself one thing: what am I bringing to the party, right? So to get someone to give you something, you got to give something in return, right? So think about, for you, it's like you have all of this expertise and experience being a nurse and looking into, health and health initiatives and working with clients. So you have a wealth of information. So you need someone who's like, okay, I could take that wealth of information, and I'm a social media expert, so I know how to navigate the social media landscape. Why don't we work together? So you got to put those two things together, but that's about, going out there and meeting people. The other thing is, you guys all have to network, okay? Part of building a business is not sitting on your island and waiting for things to come to you, because that does not happen. I'm just telling you right now. So, you got to go out there, go to, women's development events, go to entrepreneurship events and go and meet people and talk to them about what you're doing and be excited about it, right? And then you're going to attract someone else who's like, okay, this is perfect. I love health and nutrition. I don't have the resources or this information and this experience that you have, but I know how to build a website. I know how to talk on social media. So there you go. Now you just got to go out and find them.
When it comes to HIPAA, and I apologize if I mentioned this earlier in the presentation, like let's just say client testimonials. I would assume they would sign a waiver if they wanted to use their
Exactly.
testimonials and
Exactly.
little video.
Yeah, especially if so I've had a situation where I've represented doctors, okay? And they've been at conferences, and those conferences are taped, right? And, pure common sense, right? Don't put your patient's picture, or pictures of your patients on the screen if the conference is taped, because someone's got their phone, or they're taking something, or they're like, they're on Facebook, they're taking a picture, and then suddenly the world knows about it. So my point is for you is like, especially if you're in any sort of health care or anything that qualifies as health care or patient practice, space, you need to get consent forms, just like you need to get permission for copyrighted works. Lazy people have huge legal bills, right? Because they didn't do the proper due diligence to do what they're supposed to do, right? And we live, unfortunately, in a very litigious society, and not to be your token negative lawyer, but I'm telling you these things because, like I said at the beginning of the, talk, is you will never get back time, okay? This day will be the youngest, you were, and then so my point being is like, what you want to do in business is be very prudent and make very practical decisions so you're not going backwards. When you go backwards, you pay a lot of money to lawyers. Any other questions?
I'm reading this part of the resources that says that an employer can terminate an employee because of their social media activity. Is that like a rule, or
No.
did I sign something
So
that says you
No,
cannot
so that's not unfettered. Meaning, just because you go up and post something on social media, I can terminate you, because there are social media policies that the law dictates that allow employees to have the freedom of speech, right? But let's say, for example, I signed a handbook with you and a non-confidentiality disclosure agreement that said the company's business essentially is the company's business, and then I go on social media and I'm like, by the way, we're just launching this product, okay? And I reveal it to the world, right? Or my friends who might repost it. And then suddenly I'm in breach of the confidentiality trade secret agreement that you might have had with me, okay? And then you can terminate me, right? Because I violated that policy.
I kind of asked this earlier, but so I run a small dining group on Facebook, a membership, and we do events, and so sometimes I'm looking for pictures of food, and there's no profit involved. We just put together a dinner for them. When I use pictures, am I liable for anything?
Yes, if it's someone else's. So you have to get permission from the person who owns that picture, unless it's in the public domain or that person encourages people to use their pictures. So just think about it. If you don't own it, don't use it, ask permission for it.
So what's my liability limited to?
Well, if it's a registered copyright, then depending on whether or not if it was intentional or not, then the person could get statutory damages against you. So meaning if that person registered their photo collection with the U.S. Copyright Office, and then you took it and you've been using it on your site, and that copyright is protectable, then depending on the instances, the facts between you and that person, you might be liable for punitive damages per the statute, the U.S. Copyright Act, which take that simple copying out of a simple act of just copying to something that could cost you hundreds and thousands of dollars, right? So just don't use it. That's the general rule.
So I guess then the other question is, how do I specifically tell something to be public domain versus private ownership?
Well, if you got it on someone else's website and you know that it's their picture, you should ask their permission. If I'm sure there are tons of sites right now that have photography that's, available for people to use, like stock photos, and then they'll say, these are stock photos in the public domain. Now, if you had no idea, and if it was innocent, you thought it was in the public domain and it really isn't, then what the copyright holder would send you is a cease and desist letter, and you would just have to immediately stop using it. And depending on if they pushed it further or not, I don't know. Remember, they could sue you, but they could not prevail depending on your set of circumstances. But again, just adopt, general practice. If it's not yours, get permission for it.
We most typically just Google things when we go to Google Images and find whatever pictures we like, right?
Yeah. Well, it's can't tell you that's legal, so you're talking to a lawyer.
I come from the music industry, so I'm really big on consent,
Yes.
waivers, all that. But I'm kind of in a new space with the social media. And I wanted to ask you, just to kind of camelback off what he was speaking of. I have photographers that come into our events that we're covering, and they'll take photos, and I'll ask for consent or an agreement. They'll send me over the pictures with their watermark.
Yeah.
Do I need a full consent?
Well, if they've agreed, in writing and via email, and the watermark has the photograph is attributing the ownership to the photographer, then you're set, right? Right?
But is there any way with that agreement that, do I have to have their huge watermarks, on it?
Well,
Can I
if
request that?
well, it's up to, that's a negotiation, right? So they're like, okay, part of the only way that we're gonna lend you these photographs or let you use them on our site is if you give us credit, right? That's probably why they have their.
Yeah.
So if you don't like the watermark, you could just say, is there any way you could remove the watermark and I might attribute credit to you on the
Or
site?
reduce the size so it doesn't
Exactly.
disturb the photo. That's
Yeah,
what I was doing.
yeah.
I just wanted to make sure I was doing it right.
Yeah, as long as, again, you get permission from the
Yeah.
owner. Anything else? All right, thank you so much. Have a great Friday. It was really nice to have you guys. No problem.
My name's Jenny.